Mr. McCrary, did you have any objections, sir, to the media request? You indicated that you did, that you had an objection, and the court indicated that its tentative was to grant the request for media coverage. Did you wish to put that on the record or no?
Yes, I mean, I'd like to put it on the record, only because I have other children than my 18-year-old son, which this matter is involving.
Okay, but only as it relates to the media request.
Oh, I just wanted to make sure that my other children weren't in the media if I mention their names or if it comes up in the proceedings.
Okay, thank you. And so the court finds good cause to grant the media coverage. The media coverage was granted as relates to ABC 10 News, and the court authorizes the sharing of media news feeds with other media outlets. So that is authorized. Upon further review of this case, the court finds that Mr. McCrary was before the court on October 7th, 2025. At that point, his request for self-representation was granted. However, the court finds that his acknowledgement of advice of rights regarding extradition was not signed. Sir, prior to representing yourself, were you advised of your rights regarding extradition?
All I know is that I was supposed to be on a 72-hour hold, and...
Sir, my question to you is, were you advised of your rights regarding extradition?
No, Your Honor, I was not.
The court advises you as follows. The defendant in this matter has been advised of the following rights: the right to require the issuance and service of a warrant of extradition by the governor of the state of California before he can return to the state demanding his extradition, the right to have a qualified lawyer represent him in the proceedings in this state at all stages of the proceedings, and that said attorney may be the defendant's own choosing or shall be court appointed if the defendant is unable to afford counsel. When a warrant is issued by the governor of the state of California and served on the defendant has the right to test the legality of such warrant by a writ of habeas corpus and has the right to a reasonable time after the service of said warrant in which to apply for the writ of habeas corpus. The court finds that the defendant has been advised of his rights regarding extradition on the record in open court on October 15th, 2025. As relates to the complaint, sir, are you prepared to go forward with your arraignment?
Yes, Your Honor.
Please do so.
I wanted to call attention to the emergency motion that I filed. Based on the fact that the 50th District has completely continued to violate all of my rights, my 4th, my 5th, my 14th Amendment, my right to due process is constantly trampled, and I've figured out why, because under due process clause of the 14th Amendment, personal judgment is void if rendered by the court, which has no jurisdiction over the defendant. That's Penmore versus Neff, 95 U.S. 714, 24L, ED 565, and Michigan has no jurisdiction. Before we proceed, we need to establish jurisdiction. It's imperative that we establish jurisdiction.
People?
Your Honor, the people would argue that this motion is not relevant to the proceedings before the court, that it is now time to either admit guilt or not guilt as to the fugitive complaint that the people have filed.
Okay, thank you. Sir, did you care to respond before the court rules on your motion?
There's no injured party, Your Honor. Oh, I'd like to also say I'm here in special appearance.
Specially appearing for who?
I'm here on special appearance.
Sir, who are you specially appearing for?
I'm specially appearing for Darius McCrary. I'm here pro per special appearance.
And when you say you are here pro per and special appearance, who are you?
I'm an authorized signatory thereof of the estate and the executor of the estate.
Who's the state?
The McCrary estate.
And your name is?
I'm Darius. I'm the authorized signatory thereof, Darius McCrary.
And you?
McCrary.
Okay, thank you. Anything else as it relates to your motion?
I would also like to add that there's been as far as corpus delicti is concerned, I wanted to know who's the injured party.
The court finds that the issue before this court is the issue of extradition. This court is not the demanding state where many of these issues raised by the defendant may be relevant. This court is tasked with ensuring that the defendant is returned to the demanding state. That will happen either one or two ways. He will waive extradition or he will plead not guilty to the complaint regarding extradition, at which time a governor's warrant will be provided to the court at a later date. Those are the things that this court is tasked with deciding at this point in time. If you have any issues regarding the charges pending against you in the demanding state, then you may raise those in the demanding state. The thing before the court today is the extradition and the extradition only. As relates to the extradition, is there anything else?
Well, Your Honor, is it possible that we could discuss a bail?
Bail arguments are heard after the entering of a plea has taken place. Again, as it relates to the extradition, are you prepared to proceed?
Yes, Your Honor.
Please do.
Meaning?
You're here for an arraignment. You were granted the right to represent yourself. When you made that request, you indicated that you would have the ability, the knowledge, the education to represent yourself in these proceedings. That request was granted. You were advised that you would not receive any special treatment as a pro se litigant, that you would be treated the same as an attorney. You are here for an arraignment on the complaint. Please arraign yourself.
Well, I'm asking, can we discuss bail, Your Honor?
And I have told you that the discussion of bail arguments are conducted after the entering of the plea.
Okay, Your Honor. So I guess I'm playing. What is it? No. I really.
Do you understand the legal proceedings pending before you?
I do, Your Honor. I do, but I wasn't.
So then please proceed with the arraignment.
So I wasn't here. I wasn't aware that we were here to contract today.
Okay, thank you. Attempted to conduct the arraignment with Mr. McCrary, and it is evident to the court that he is unable to understand and appreciate the legalities of these proceedings. As such, the court finds good cause to revoke his pro per status. The court appoints the office of the primary public defender's office to represent him. This matter is trailed.
Thank you.
All right, thank you.
Thank you.
Your Honor, client number 105, take B.
Good morning, Your Honor. Vanessa Duval, Deputy District Attorney for the People.
Julie Gibson, Office of the Public Defender, on behalf of Mr. Darius McCrary, who is present in custody. Your Honor, we are here for arraignment on the complaint. He's been advised of his constitutional rights, previously signed the acknowledgement. We are entering pleas of not guilty, denial to any and all allegations, asking for appointment of the primary public defender's office, and would like to be heard with regard to his custodial status.
Okay, thank you. Thank you, and just for the record, the defendant did not sign the advisor of rights regarding extradition. Previously, the court went over those advisors with him in open court today on the record.
Thank you.
The court appoints the office of the primary public defender's office to represent him. Mr. McCrary's true name and date of birth appear on the fugitive complaint. He was advised of his rights regarding extradition. He waives further reading of the charges. The court enters his not guilty case to the charges and his denial of the allegations. The court has appointed the primary public defender's office to represent him. As relates to dates, the court will set this matter in 30 days for the governor's warrant, and that date is?
That date would be November 14, 2025 at 8:30, Department 101.
All right, thank you. As it relates to bail, the Iowa counsel wish to be heard.
Yes, Your Honor.
Yes, sir.
Please proceed, Ms. Gibson.
My argument has, I would ask that Ms. Duvall, you heard first, my understanding she's going to make argument, and I don't have all the facts as to why it should be no bail, and I would ask for her to make those arguments first.
Okay, thank you. Ms. Duvall?
Yes, Your Honor. The fugitive is before the court today for absconding or forfeiting bond on a non-payment of child support case out of Michigan. Clearly, Mr. McCrary is not attending to his family matters. He has 2 daughters and 1 son, and this matter is regarding 1 daughter who lives in Michigan. He has previously been ordered to pay child support. As of August 20th of last year, he owed $75,473.26. He owes substantially more at this time. However, Michigan could not give me a figure due to privacy reasons. The defendant has been arrested twice in the past on these same charges, in 2015 and 2023. In 2004, he's been arrested for disturbing the peace. Back in 2023, the fugitive had to be extradited from Los Angeles for these very same charges. The defendant was arrested coming back from Mexico. According to his agent, he was looking at buying real estate down there. He lists his current address as Woodland Hills, which is not in the county of San Diego, but in the county of Los Angeles. He has no ties to San Diego or Michigan. When he left Michigan, he actually had what they describe as a TETR, which is electronic monitoring, when he left the state of Michigan. For all those reasons, the people would argue that he is a flight risk. He's failed to take care of his obligations back in Michigan. We'd be asking for no bail in this matter.
Thank you. Ms. Gibson?
Your Honor, we are asking the court to set bail in the amount of $50,000, an amount for which he can afford. He made multiple court appearances on this case. There was the last time that apparently there was a notifying letter that was sent. They sent it, the district attorney's office in that state had both his email address, his phone number, as well as his counsel's email address, and they chose to send a notifying letter to a P.O. box that was not monitored by him often. And so with regard to the issue of coming across the border, he was across the border working with a group to build homes in Tijuana. There was nothing nefarious about what he was doing. We're asking the court, again, since there are no failures that he has other than that demanding state, we're asking the court to set bail in the amount of $50,000, an amount for which he can afford, and he will make his court appearances. I've already talked to people that are here on his behalf, that are part of his team and represent that he will be returning to the demanding state. He is ill right now, and so I apologize to the court that it's taken a while to have the conversation, but he is adamant. He is a renowned figure. Everyone knows, that's why there are media here on his behalf, that he's going to appear in court. And I understand what the district attorney is saying with regard to prior incidents, but if they wanted him to appear in court, they had multiple ways to get him, and he did not know of the appearance date. So we're asking the court not to release him on OR, but to set bail in a reasonable amount that is $50,000 for him to make his court appearances.
Okay, thank you. Both counsel submit?
Yes, Your Honor.
Yes, Your Honor.
Thank you. The court has considered the arguments of both counsel here today, and the court finds as follows. The court finds that the defendant has previously been extradited, that he was arrested coming back from another country. It has been represented to the court that he has no ties with the demanded state, and most notably, that he was on bond previously and absconded. Based upon those factors and findings, the court finds that the defendant is a flight risk, denies his request to set bail. He'll continue to be held without bail.
Your
And
Honor,
that is the order of the court.
I apologize. Thank you, Your Honor. At this time, after having previous discussions with Mr. McCrary, he is prepared to admit identity, I think he has, and to waive extradition.
He has not admitted identity.
Your Honor, he does admit identity, and he is asking the court to allow him to sign the extradition paperwork, and so we're getting some now. I did not have them. I'm not sure where they are from before, but that is our request to the court.
Okay, thank you. Sir, are you Mr. Darius McCrary?
Yeah, I'm Darius McCrary, yeah.
Okay, thank you. The court confirms the identity of Mr. McCrary as he's identified himself as Darius McCrary.
Yes.
Can we also get an audit? Oh,
Hold on. Your Honor, I apologize. It's going to take me a moment to complete these. How would the court like to proceed? Does the court mind waiting while I fill out these forms? They're blank.
Court in a brief recess.
Thank you, Your Honor. Sir, I don't know what an audit is.
Ms. Gibson, you prepared to proceed?
Yes, Your Honor.
Okay, thank you. We're back on the record. The court is in receipt of the signed acknowledgement of advisement of rights regarding extradition signed by the defendant. The court is in receipt of a signed waiver of extradition to the state of Michigan signed by the defendant, and the court finds a valid waiver of extradition to the state of Michigan, signs the waiver of extradition. As such, this defendant is remanded to the custody of the sheriff without bail, and the court sets a 30-day date review hearing in this date, and that date is
November 14th, 2025 at 8:30, Department 101.
okay, thank you. People, given that the defendant has waived extradition, what is your request as it relates to the fugitive complaint?
People move to dismiss it, Your Honor.
That matter is, that request is granted, that matter is dismissed. Thank you both.
Thank you,
Your
Your
Honor,
Honor.
with the court do a medical referral, he is quite sick.
The court grants the request and authorizes a medical referral for the defendant. That concludes this matter. Thank you both.
Thank you, Your
You're
Honor.
welcome. Thank you, Your Honor.
Thank you.
Your Honor, that concludes the morning's calendar.
Thank you. Court is in recess.